Good morning, everybody. Salam Sajatra. I hope everybody is doing well this evening and welcome to today's online panel discussion on the theme Malaysian criminal law sufficient or not. I am your host Ayn and we are joined by a handful of honorable professors today to discuss the question, do the laws on rape for males in Malaysia require a change? To give you a bit of context, according to recent statistics from Malaysia, the number of reported occurrences of sexual harassment and assault against males has significantly increased. This has led to legal experts to call for a revision of the definition and prosecution of rape under Malaysian law with a focus on male victims. According to Section 375 of the Penal Code, rape is precisely defined as a man engaging in sexual activity with a woman without consent. Men are not considered as a potential rape victim under this gender-specified criteria. This legal structure implies that only women can be rape victims under Malaysian law, whereas only men can be perpetrators. Legal experts and advocacy groups claim that current laws fail to appropriately recognize and protect male rape victims, prompting calls for gender-neutral legal standards that assure equal justice for all victims of sexual abuse. England and Wales, on the other hand, have addressed these issues by enacting significant legal reforms. In England and Wales, men were not legally recognized as victims of rape until 1994. However, later the definition of rape was expanded to include male victims. Without further ado, let's dive in.
By examining the wordings in Section 375, we can first see that it uses the pronoun her to describe the victim and the term a man to describe the perpetrator. This enforces the idea that under the Malaysian legal system, rape can only occur between a man and a woman. This also means that men cannot be victim of rape under this provision, as male rape victims are not covered under rape but are instead covered under other provisions. Section 354 talks about the assault or use of criminal force to a person with intent to outrage modesty, whereas Section 377C talks about committing carnal intercourse against the order of nature without consent, etc. As the two statutes carry different penalties as compared to Section 375, this means that Section 354 has a maximum 10 years of imprisonment or fine or whipping, and Section 377C has a maximum 20 years or whipping as penalties, while Section 376 lists out the punishment for rape, where the penalty ranges from 8 to 30 years of imprisonment and 10 strokes of whipping maximum.
Right. To what extent can other provisions be used to protect male victims?
Well, Section 354 discusses the following. As the statute does not explicitly state the gender of the assailant or the victim, this section is applicable to male victims of sexual violence. However, there are several issues with this approach. Firstly, the phrase modesty often implies a less severe context compared to rape, where it often describes scenarios like molestation, flashing, or etc. Secondly, the section explicitly states the use of criminal force. As we can see in Section 350's definition and illustrations, this leaves gray area for cases where the victim was raped through held to consent halfway through the sexual intercourse, or dubious consent, or undue influence from the assailant. Section 377C also focuses on the non-consensual element of homosexual sexual intercourse within two males, compared to Section 377A, where it criminalizes deviant sexual behaviors, which is oral and anal sex. However, due to the illegalization of male homosexual sex by 377A, it makes it hard for authorities to differentiate and validate the consent element between alleged perpetrator and victim, as confessing that the sex was consensual would mean criminalization under 377A, but the societal norms or standards in Malaysia also makes it hard to establish proof for 377C between two male individuals for non-consensual sex. By differentiating a different section dedicating to non-consensual male homosexual sexual intercourse, male victims often face a dilemma on deciding whether to bear a heavier burden of proof towards their rapist or admit guilt for sodomy under Section 377A and face punishment along with the rapist. After comparing the statutes of rape and applicable statutes on male rape victims, we can clearly see that male rape victims do not get their justice served proportionately as compared to their female counterparts. Furthermore, it is also harder to prove guilt with Section 354 and 377C when it comes to male victims. Our societal norms and standard and legal system holds men to a more powerful position, which when situation arises where they are the victims of rape, they bore extra burden to prove that their perpetrator has raped them.
So, what do you think, Amina?
Other than the gender-specific language of rape laws, victims under the age of 18, they may seek justice under Section 14 of the Sexual Offences Against Children Act, which is physical sexual assault on a child. Primarily, the issue this provision poses, it lies in its ambiguity. It does not clearly and explicitly exclude sexual penetration. So while Section 377C of the Penal Code does cover this, its substance is nonetheless generic because it is not specific to child victims. So the enforcement of this particular act in Section 14, it differs from that of Section 375 of the Penal Code. It carries a maximum punishment of 20 years imprisonment and whipping. So indeed, the initial purpose of the Sexual Offences Against Children Act, it's for offenders to not escape the law based on any technicalities of the Penal Code itself. However, there comes a greater risk of a misclassification of the severity of an offense. A concerning number of rape incidents in Selangor, which is the state with the highest number of reported cases, are children under the age of 12. Hence, the impact of the Sexual Offences Against Children Act is much more important than we may think. So, while the Sexual Offences Against Children Act is the primary act to refer to by all parties in sexual cases concerning children, the matter of access to justice, it comes into question. In what circumstances would a charge under that act result in a lesser sentence, even if the offense may be more suitable under a charge under the Penal Code's penalties? So such discrepancies emphasize the shortcomings of Malaysia's legal framework regarding rape laws.
So, actually, what is the impact of Malaysia's language on rape laws?
Right, so despite a general understanding that Malaysia's gender-specific language brings about limitations, Malaysia still does not use gender-neutral language. Why? Many argue that with the lack of statistical evidence of male rape victims, that gender-neutral rape laws, it would not properly reflect the reality of rape, as there is only evidence to back men raping women. So the lack of statistical data, it actually stems from Malaysia's deeply rooted patriarchal culture, by which male victims, they feel apprehensive to speak out about their experiences in fear of being judged and being ostracized. Consequently, this stigmatization, it discourages any sort of desire to revise the language of the laws. It is the same stigma that carries on to the law, whereby male victims can seek justice via other provisions, but the societal and legal weight of these charges, they do not match that of rape. So alongside the difficulty in proving the alternative charges, they are not taken as seriously in society and are thus disregarded more frequently in a legal setting.
I see. And Felicia, how can we compare this with the law in England and Wales?
The social stigma in Malaysia surrounding male rape, including assumptions that male victims are homosexual or somehow complicit, not only silences survivors, but also reinforces the myth that male rape is either impossible or insignificant. Before 2004, UK law didn't legally recognize male victims of rape. That changed with the Sexual Offences Act 2003, and in the case of R.V. Ismail, the court convicted a man for raping another man. This case shows that in the UK, rape is about the act, not the gender, and everyone deserves protection. Under the Sexual Offences Act 2003, rape is when someone uses their penis to force another person, a man or a woman, to have sex without their consent. This includes oral, vaginal, or anal sex. For example, if a man is forced into sex, he is recognized by law as a rape victim. Similarly, if a man rapes another man, it is also called rape. Here, the key point is anyone can be a victim and anyone can be charged as a rapist no matter what their gender is. Consent means agreement by choice with the freedom and capacity to make that choice, as demonstrated in the case of R.V. Alakboja, where the court held that mere submission does not amount to genuine consent. And if someone uses an object or another part of their body to assault someone sexually, That is also a serious crime under the English law, and it is called assault by penetration. It carries the same penalty as rape. As Ian explained earlier, Malaysia's definition of rape was found in Section 375 of the Penal Code, and under that law, rape can only be happen to women and can only committed by a man. This means that when a man is sexually assaulted, even in the same way, it is not considered as rape under the Malaysian law. Instead, the case is charged under Section 377C of the Penal Code, which describes as carnal intercourse against the order of nature. In short, the legal system in the UK offers a more inclusive approach to deal with sexual violence. It gives male victims the recognition and protection they deserve. However, as Amina mentioned earlier, while Malaysia has a special law, which is the Sexual Offences Against Children Act 2017, to deal specifically with children's sexual offences, the UK does not have an act like this. Instead, they combine both children and adult sexual offences under the Sexual Offences Act 2003 and addresses protection for children to specific sections such as Section 9 to Section 15A. This shows that our legal system is capable of enacting targeted laws when necessary. Thus, in our opinion, Malaysia should adopting similar legal reforms to support all rape victims regardless of their gender.
So, Parvin, what steps can we take in the law to ameliorate the aforementioned issues?
In Western countries, there is a trend of legislative changes to remove the gender impositive undertone of the assailant. However, the changes made were mainly made to include male victims. The mentioning of penetration implies that the assailant is either male or female with items or tools that can be used to penetrate the mouth or anus of the victim. An example of this is the Crimes Raped Act 1991 in Victoria, Australia, where the wording specifically mentions intentionally sexually penetrated. This also reinforces a stereotypical idea of rape that it can only occur if the victim was penetrated. In reality, female assailants do not need to penetrate the victim to accomplish the crime itself. In fact, the penetration is done by the victim towards the assailant, with the only key element of the crime here being the power dynamics between both parties. Singapore's 2020 sexual assault laws were amended to recognize male rape. Singapore's 2020 sexual assault laws were amended with the addition of Section 376, subsection 2 of their Penal Code to recognize any person who sexually penetrates or forces a man to penetrate without his consent to be guilty of rape. This provision still classifies the above as rape, equating its legal and societal weight with that of rape under Section 375, penile penetration into the vagina. Instead of using one provision with gender neutral language, Singapore opts to retain gender specific language by including separate provision catering to both female and male victims.
What about actually using gender neutral language?
An example of a country that has gender neutral rape laws is South Africa. Section 3 of South Africa's Criminal Law Amendment 2007 covers rape using person and complaint when referring to the offender and victim of sexual penetration. Additionally, the definition of sexual penetration as per Section 1 has been widened. Sexual penetration includes the penetration of one's genital organs or other body parts, objects, or even an animal's genital organs into or beyond the complainant's genital organs, anus, or mouth.
How should Malaysia reform their law then? Gender specific to include men or gender neutral to be inclusive to all?
Both approaches are inclusive of that of male victims, but carry different pros and cons. While using gender specific language, as Singapore did, is precise and leaves no room for confusion or complication, its place in a modernizing society is doubtful. As global society develops, more and more individuals do not attach their identity to a gender. Although a separate gender specific provision would solely focus on an individual's biological feature, gender specific language may still be deemed discriminatory and exclusive to such individual. On the other hand, gender neutral language is inclusive to all. However, its broad nature via these neutral interpretations, as per South Africa's rape laws, concern a variety of sexual penetrations that classify under rape, potentially leading to a legal ambiguity and consequently the enforcement of rape laws. As mentioned before, Malaysia's patriarchy society is one of the leading reasons male victims do not report rape incidents. The stated provision may not encourage male victims at the same level as per gender-specific provisions would.
I'll open to the floor then. What reform suggestions do you all have?
We can use gender-neutral terms and pronouns referring to both the perpetrator and the victim. Terms like a person, an individual. We can also use phrases like unconsensual sexual acts instead of specific terms like penetration. Phrases like sexual organs or tools would also help in the reform of the phrasing of the wordings of the statute.
I think there should be a separate provision with language catered to men, like Singapore's language, because the men in Malaysia already feel so afraid to speak up for themselves. So it may not be as encouraging for them if there was one provision for all genders. And I also feel that the word sexual penetration should be used, and it should be very specific what may fall underneath that, as South Africa's law did, because rape is a very heavy charge and it requires very specific classification.
To wrap it all up, this presentation primarily discusses male rape victims in relation to Section 375 and 377 subsection C of the Malaysian Penal Code, with a number of additional parts supporting the Malaysian legal perspective on the matter, including Sections 354, 350, and 377A. When comparing and analyzing the two jurisdictions, as well as proposing tenable changes for the Malaysian legal system, English laws were also cited. In addition to shedding light on Malaysia's Sexual Offences Act for children, the Sexual Offences Act 2003 offers more gender-neutral wording to encourage inclusivity in victimology, bolstering the claim that our legal system is capable of targeting demographics for protection purposes. Thank you.